Hello, my name is Thomasina Thornton, and I am a licensed New York and New Jersey trust and estates attorney. Welcome to this segment of Estate Planning Essentials. Today's topic will be a continuation of Power of Attorney documents. This is part 2 of a 6-part series. If you missed part 1, then please check out my videos on either YouTube or my Facebook page, The Law Offices of Thomasina Thornton, or join my Estate Planning Essentials group on Facebook. Now, let me give you my disclaimer. By no means is this video intended to give you specific legal advice. Everyone's situation is going to be unique. But if you live in the states of New York or New Jersey and you have questions, by all means give me a call. I would love to talk to you. But if you live outside of those states, then I would suggest that you seek counsel in the state in which you reside. So with that said, let's get started. Okay, so during part 1, I discussed what is a power of attorney. A power of attorney is a written legal document that allows you to name a person or persons to make legal and financial decisions for you in the event that you are unable to do so on your own accord. Now, if you ask me who needs a power of attorney, I would tell you anybody over the age of 18 could benefit from one. But that's very broad. So what I'd like to do is to try to narrow that down into what I consider the top 5 categories of individuals that could benefit from having a power of attorney or a POA. So, number 1 would be individuals that have an illness, people that are sick. You know, if you have been diagnosed with cancer, or you need major surgery, or you have some kind of long-term debilitative condition, that's going to be very difficult news to deal with. And there are physical limitations that may accompany your illness. There is the mental and the emotional stress of having to work with the treatment plan or figure out how that illness is going to work in conjunction with your lifestyle. And rarely does anyone suffer an illness and say, this is a good time to be ill. There's never a good time to have an illness. And an illness is not going to prevent you from having to still fulfill your financial and legal obligations. So with all of those factors, they can have a direct impact upon your healing process. So I would encourage you that if you are ill, or even before you are ill or have an illness, that you put together a power of attorney whereby you name someone else to be able to handle things until you're back on your feet, so that you can spend your time and your energy on the process of getting better. Now, my second category would be elderly people. Now, how do you define elderly? You know, is it 60, 70, 80, 90? It's different, obviously, for every person, and everyone will age differently. Some people may age more gracefully than others. So if you do not consider yourself to be an elderly person, you may still have people in your life that are elderly, your parents, your grandparents, distant relatives, individuals that you know may suffer with Alzheimer's or dementia, or their thought process is slowing down, or there's confusion, and they need assistance handling things such as their checking accounts or savings accounts, or managing repairs around their home, or dealing with Social Security or disability issues, or Medicare and Medicaid matters, things of that sort. I would strongly encourage you to have those elderly loved ones put a power of attorney in place while they still have the mental capacity to execute that type of a document. Now, the third category would be people that are going through a divorce or recently divorced. Most people that have gone through divorce recognize that it can be a traumatic experience, so certainly it's unpleasant. And now, if you find yourself in that situation, most people do not want to have their ex-spouse named as a fiduciary. So that means that now you're going to have to start the process of figuring out what the marriage dissolution will look like, changing your ex-spouse's names on accounts. And that also means that you now need to create an estate plan, particularly a power of attorney, that will no longer include your ex-spouse, but will have your new agent listed as your fiduciary. The fourth category would be people that are in same-sex relationships that are not married. Now, in June of 2015, the Supreme Court, in a 5-4 ruling, guaranteed a constitutional right to same-sex marriage. Now that doesn't mean that the next day all the same-sex couples ran down to the courthouse or to the church and jumped the broom and got married. A lot of same-sex couples are in the same relationship that they were in prior to the Supreme Court's ruling. The Supreme Court ruling also did not automatically change people's opinions as to whether they support same-sex relationships or not. Perhaps you may find yourself in a family that does not support your same-sex relationship. And if that is the case, and they do not honor your partner's or your companion's relationship in regards to handling your financial and legal matters, then you need to create a power of attorney whereby you have named your partner as your agent or your attorney in fact. And then the last category, number 5, would be parents of young adults. Now, in some states, obviously, young adults are the age of 18. I have found in my experience that at the age of 18, 19, 20, especially if we have children who are full-time students, that there's a little bit more latitude that's given. But once a child reaches the age of 21, most states will certainly recognize them to be an adult. And if you have a young adult who has now graduated college, or they have taken a job and they're now out of the house, congratulations to them and to you. And this is the time that, apart from their achievement, it means that we as parents no longer have that obligation to do the things that we used to do. But more importantly, we no longer have the legal right to be able to make legal and financial decisions on their accord. And I find that, we think that because kids are now 21, they're young, they're vibrant, they're forging ahead, trying to reach their dreams, and all that's great. But that does not mean that they are now invincible. And we know, if it's one thing, that life teaches us that sometimes, things happen that are just not supposed to happen. Sometimes it snows in April. So that said, for our college grads or our young independent children, one thing that I recommend is, if they've graduated from college, great, give them that graduation gift. Or if they're moving into that first apartment, it's wonderful to give them that housewarming present. But more importantly is to sit down and have a conversation with them and talk to them about creating a power of attorney document, such that if you need to step in and help them, you have the ability to do that. Because we always hope for the best. And we want our kids to be independent, but at the end of the day, we want to always have their back if we can. And certainly, sometimes we need the legal means to be able to do that. So this is the end of part 2. I hope that you will join me for part 3, where I will be discussing how do you go about choosing a good agent. As always, it's been a pleasure. I am Tommy Thornton. I'm a trust and estates attorney. I thank you so much for watching. I hope that you found this video to be helpful. And as always, I wish you and me wisdom. And please be well and live long. I will see you next time.